regulate or interfere with their right of privacy. And that right cannot be extended in civil cases, so that they cannot be asked to pay compensation or damages. What is your answer on this aspect? The straight question is whether this Joseph Saini's case is not applicable to civil cases like yours.
Your Lordship, the counsel submitting the answer for the questions raised by our Lordship, that the appellant is seeking injury to redress the harm caused, only seeking to allow the civil injury in cases of intentional interference and malicious interference, Your Lordship. Lordship, by referring to the para 42 of the Joseph Shane judgment, where in that case, Justice Deepak Mishra have clearly stated that there is no doubt that the adultery was decriminalized, but it doesn't mean that it creating a license to enter into the spouse's relationship. So that is my answer to the Lordship. Lordship, may I proceed? Much obliged, Your Lord. Lordship, further, the counsel submitting that the respondent actions, including repeated inducement, such as urging Mr. Gupta to leave the appellant and systematically fostering emotional and physical dependency, which will go far beyond the private choice and amounts to intentional and wrongful interference, Your Lordship. Your Lordship, further, the counsel would like to draw your attention towards the recent reasoning. Lordships, kindly refer page number 16 and para number 19 of the memorial. Page number 16 and para number 19 of the memorial, Your Lordship. In Shelly Mahajan versus Manushree Bahal and others, in this case further strengthens the position by recognizing that a spouse's rights to consortium imposes a corresponding duty upon the third parties to refrain from deliberate and unlawful interference. That means here, the Hoffold's theory was applied here. The Hoffold's theory is that, like, a liberty or a privilege held by one person necessarily implies that another person has a no right to prevent or interfere with the exercise of that liberty or right.
We understood the principle laid down in Shelly Mahajan's case.
Indeed, Your Lordship.
Okay.
Indeed, Your Lordship.
Delhi High Court judgment, isn't it?
Indeed, Your Lordship.
Okay. We want to invite your answer by extending this judgment in another example. Okay. It was held that the decriminalization can be confined only to criminal cases, not to others, and therefore civil liability will be very much existing if any person wants to interfere into the consortial aspects, life of the wife and husband, and affected wife or husband can sue the third party for damages. This is what held, isn't it? Take for example, a husband and wife father. We are only seeking your answer how to extend the principle laid down by the Delhi High Court in another situation, identical situation. A wife and husband are there, very loving couple. The wife sought for purchasing a necklace for the forthcoming Diwali. Husband promised it. He would purchase. They are well off. He has also having bank account to purchase a diamond necklace for her for the forthcoming Diwali. In fact, he brought they selected one item also. In the meanwhile, before fall of Diwali, the husband's sister telephoned to him that there was an urgent necessity, medical necessity for her to attend the medical necessity of her husband. She required money. The husband who has deposited that amount said that I do have, but I have to purchase necklace for your sister-in-law. But the sister requested him that it is my requirement is more urgent one. Will you please lend that amount? Husband has given it. Then wife was disappointed for not purchasing necklace. At this stage, the sister's indulgence in getting away the money which was reserved for purchasing a necklace. And for not purchasing, the wife was very much emotionally disappointed. She was a very dutiful wife. The only one wish she wanted, that she wanted to have a necklace. But that wish could not be fulfilled by her husband because of the intervening circumstances. Now, can this lady treat her sister-in-law conduct as an indulgence into their consortial life and seek for damages by filing a suit? This is also, if we extend the delay high court judgment to this given example, it also amounts to indulgence into the private life or consortium life, emotional breaking down, causing of emotional breaking down, is not it? Can we extend the Delhi High Court judgment to this type of cases?
Your Lordship, the council will.
Because you want to get advantage, I mean, you want to rely upon this judgment, isn't it?
Indeed, Your Lordship.
Hmm. If you can rely this judgment to your case, why not in the present case also?
Indeed, Your Lordship. Because in our case, the third party is not included in the family, and the sister is a part of family for the given example.
Okay, for your convenience, we can convert the example into, is not the sister, some friend has asked for help. It doesn't matter whether it is a family member or a third party. Let us say a third party, a distinct person asked, husband as a good Samaritan has given that amount. Whether in such a situation, can it be said that it is amounting to intrusion into the consortial life of the wife and husband?
Your Lordships, I can, the council submitting that if there is an like intentional or malicious interference on part of the friend or on part of the sister, then we can say that it's leading to the loss of consortium or companionship, which gives rise to the cause of action.
Here also, husband has stated, dear sister, I reserved that amount for purchasing one diamond necklace. Your sister-in-law never asked me any gift. This is the only occasion she asked. I cannot part with it. But the sister stated, it is my medical necessity.
Your Lordships, the example you are referring that, there existing a no malicious interference. In the present case, there exists a malicious and bad interference by the respondent in our case, Your Lordship.
Learned counsel, you have referred to one judgment.
Indeed, Your Lordship.
We are not discussing that judgment only.
Indeed, Your Lordship.
In that judgment, there is a mention about a third party.
Indeed, Your Lordship.
Interference of a third party.
Indeed,
Right.
Your Lordship.
Don't you think that the judgment is confined to the parties to that case only, and how we can extend it to other cases when, especially the third party who is in this problem, is not a party to the suit or the petition?
Indeed, Your Lordship. The council is submitting to the Lordships for this answer. The answer for this question was the court allowed that the case would be continued where the damages would be claimed against the third party but not the husband. Allowed by the Delhi High Court, Your Lordships. That means the court have allowed to proceed towards a trial, which they are claiming it as a civil court.
But that's confined to that case only. No, how can you extend the same rationale to other cases also when the party against whom you propose to go is not included, is not implemented?
Indeed, Your Lordship, but the court stated that there may be an attractability of a criminal liability, but it may give rise to a civil liability also when third party was involved with the intentional interference and malicious interference. So such conduct is constituted as a wrongful conduct.
Can you define what is meant by marital interference?
Marital interference. Indeed, Your Lordship. The council is answering for the questions raised by the Lordship. When there are two spouses who are, I'll give one example, Your Lordship. When there are two spouses A and B, where they are continuing their marital relationships. They're continuing their marital relationships in a consistent and stable way. But if the third party comes and induces the husband against the husband's wife, so that is called intentional interference, your lordship. That means she is making the statements against the appellant's husband that she is not good for him, and also the counsel was further submitting that here, in our case, the counsel have a the appellant has a love and affection towards her husband. So, in this case, their relationship was subsisted until October 2022, your lordship, and the cause of action was arose when the defendant was entered into the life. Like the Mr. Respondent's relation and also as well as Mr. Appellant's husband was strictly remained in the business development, your lordship. But the thing is, when they have traveled together and then when they have, but the thing is when they have traveled together and then when they are having a further discussions in the meeting, they have closely moved together. So,
For your kind information, this close moving was facilitated by Mr. Gupta, not by Miss Singh. He has booked tickets. He has sidelined the other competent man by your facts. So can we say in this case by facts, the husband is an innocuous and very innocent man, where a third woman has induced or threatened him? Your facts,
indeed,
your facts would show Mr. Singh, Mr. Gupta has orchestrated all these tour programs outside the country and etc. Isn't it? He was in the executive level, drawing 80 lakhs per year.
indeed, your
Whereas this lady is only a promotional assistant or so, commercial promotion assistant or so. So, who is in a dominant position
the wife is
between Mr. Singh and Mr. Gupta and this lady, third party?
your lordships. In this case, the wife plays a dominant role only in case of parental choice.
So
Like
we are asking in between Mr. Singh, Mr. Gupta,
indeed, your lordship.
and Miss Singh. These two are the torque feasors in a way.
Indeed, your lordship.
Okay. In such a case, if a third party has threatened or induced this innocent husband of
Indeed,
another lady, we may accept your argument that the wife may have a cause of action. But here, both people have committed. If at all a fault is committed, both people have committed, isn't it? Can you selectively choose a third party for damages, leaving her own husband?
Indeed, your lordship.
That is what one of the questions. Hmm.
Is it the pati that induced the woe, or is it the woe that induced the pati? That's a simple question we are asking.
Miss Vidyavati Singh have induced the
No, go ahead.
Miss Vidyavati Singh have induced the appellant's husband here in our case, your lordships, because there were 4,500 messages regarding the derogatory marks even against the Mrs. Gupta, your lordships, because where in the mood proposition she stated that leave her and choose us, we can build together, and also she is holding you back. Like these are the derogatory remarks which clearly indicates that there is a active participation. So,
Okay, is it innocent interference, intentional interference, or malicious interference?
it's an intentional and malicious interference, your
How
lordship.
can it be both? You have come out with a new phrase. My sincere compliments to you, learned counsel. But unfortunately, no textbook of torts you come across such an expression.
Your lordships, the answer for the questions was the intentional interference becomes malicious when there is an manipulation and targeted alienation.
Now, please, learned counsel may proceed.
Indeed, your lordships. Here, your lordships, the intention becomes the malicious when there is a manipulation and targeted alienation. This concept of alienation of affection, your lordships, further the council submits that this concept of alienation of affection was recognized in Pinakin Mahipatre Rawal versus State of Gujarat, which is a 2013 case where, in this case, the court held that the concept of alienation of affection will be proved when the estranged spouse must prove that there is a deliberate and active participation leading to the loss of consortium and companionship. So that is the reasoning the counsel for the appellant was relying on it. And then the counsel further submits that in the present case, the respondent sustained conduct evidenced through extensive communication, exclusionary action, and a planned proximity which establishes a clear nexus between her actions and injuries suffered by the appellant, including the deprivation of consortium, emotional distress, reputational harm, all of which are compensable in civil law. In your lordship, the council wants to rely on foreign jurisprudence example. Your lordships, for example, in USA, the concept of alienation of affection remains in few states such as Hawaii, Mississippi, New Mexico, North California, and Utah, etc. In these states, for establishing a claim, the aggrieved spouse must prove the three elements where it is leading to the loss of consortium, your lordship. The first element was that there must be an existence of a genuine love and affection in the marriage, which was established because in our case,
Not even persuasive value.
in lordships, the council
They are all foreign judgments and concepts, isn't it? Whereas under Indian, citing foreign judgments, but typically in the Indian context, what is a marriage? What is the concept of a marriage, at least under Hindu law, because the parties are Hindus, isn't it?
indeed your lordship,
Huh?
indeed your lordship, because I'm answering.
The parties here are the Hindus, isn't it? So Hindu Marriage Act directly applies it. What we want to ask you is, what is the concept of marriage? What is the concept of consortium? What is the loss of consortium according to the Indian treatises and the Indian concepts? Marriage is a sacrosanct, isn't it?
Indeed,
It is
your
not a legal covenant. It is not a legal contract.
Indeed,
That is
your-
first thing.
Indeed, your lordship.
The second one is consortium rights, private rights in between them. A third party, if intrudes into their private life, let us say agree with it. Whether the common law torts can be resorted to take advantage and ask for damages. This is the fundamental question involved in it, isn't it?
Indeed,
In this context, whether you have any Indian citations,
indeed,
you are showing Shelley, that is the recent one of the Delhi High Court, which we have to decide whether can be or cannot be applicable. Any other judgments?
Indeed, your lordship. The council have cited previously in Pinakin case, Pinakin Mahipatre Rawal versus State of Gujarat. In that case, the court acknowledged that from para 13 to 15 of the case judgment, lordships kindly refer to the compendium. Page number 5, your lordship. Lordship, I apologize. Kindly refer page number 11. Lordships, the council relied in this case because from para to 13, 14, 15, in that case, this alienation of affection by a stranger, that means even there may be a stranger and third party, if proved, is an intentional thought of interference in the marital relationship with intent to alienate one spouse from other. So, this alienation of affection was evolved from the Anglo-Saxon Anglo-Saxon law, which is a common law jurisprudence which was adopted by India. And in this case, they have clearly stated that in order to prove there is an intentional and wrongful interference, the spouse have to prove that there must be a active deliberate intention which leading to the loss of consortium or lordship. If a third party is instrumental for disrupting her marriage by alienating her spouse's affection, companionship, including marital obligation, we find the disgusted spouse proceed against the intruder into her marital home, matrimonial home, which is a clearly stating in that case, your lordship. And the objective is to preserve matrimonial harmony by deterring the wrongful interference, thereby to save the institution of marriage, your lordship. So, both the spouses have a valuable interest in the married relationship, including the intimacy, companionship, support, duties, and affection, and welfare of the children.
So you say that Pinakni case will come to your aid.
No.
You say that Pinakni's case will come to your advantage. Okay?
So, the counsel for the appellant respectively submitted that, hence, in the light of above stated authority, it is construed that the necessary elements of a tort, the necessary element of a tort was clearly established in our case. Therefore, the counsel have completed. The counsel one have completed with her arguments. Now, with your lordship's due permission, now my co-counsel would like to continue with remaining two issues. Much obliged, your lordship. It's an honor to argue before this Supreme Court.
May it please this honorable court, the counsel seeks permission to address the bench. The counsel seeks permission to address the bench as your lordships. Much obliged, your lordships. The present counsel shall be addressing issue number 2 and 3. Issue 2 consists of mainly three aspects. Firstly, the appellant submits that section 7 expressly confines the jurisdiction to parties to a marriage, thereby excluding the strangers to the relationship. Your lordships, further, a plain reading of section 7 shows that it covers the matrimonial relief such as judicial separation, dissolution of marriage, custody, maintenance, and etc., where it shows that all the disputes are between interstate spouses or even their children, clearly establishing that the legislative intent to restrict the jurisdiction to the disputes between the spouses. Your lordships, it is further submitted that even where a third party may be connected to the breakdown of the marriage, there can be neither a necessary party nor a proper party, as held in Manjul Joshi versus Bhavna Kurana. Your lordships, moreover, in the case of K. Abdul Jalil versus T. A. Shahida, the honorable court held that the phrase arising out of the marital relationship must be interpreted broadly. Your lordship, I seek to draw your kind attention that here the breadth remains confined to the matrimonial disputes and cannot be extended to independent claims against the third parties. Your lordships, further, in the case of Raki versus Jayendra, where the court has invoked the doctrine of ejusdem generis, where it stated that the phrases should be interpreted, the general words should be interpreted in the same way the next words should be interpreted. Similarly, here under clause A to C, the courts have interpreted. There are phrases stating that it is a suit or proceeding between the parties to a marriage, and similarly, the court should interpret clause D, where a phrase circumstances arising out of matrimonial relationship should be interpreted only between the parties to a marriage. Your lordship, further, the counsel submits that clause D of section 7 clause 1 explanation D states that a suit or proceeding for an order or injunction. Here, the counsel submits that the counsel seeks the remedy rather than an order or injunction from the court. So here it is in the circumstances arising out of matrimonial relationship. So it falls within the circumstances arising. It doesn't fall within the circumstances arising out of matrimonial relationship because the council is seeking a remedy rather than an order or injunction. Your lordships. Further, the council submits that the present claim being an independent civil action against the third party falls outside the scope of the jurisdiction of family courts under section 7 and must be adjudicated by civil courts. Your lordships. Secondly, the appellant submit that the suit for damages is an independent civil claim and lies outside the scope of section 7 and thereby section 8 is not section 8 doesn't bar the jurisdiction of civil courts. Your lordships. The determinative test is the nature of cause of action and the relief sought. Your lordships, further kindly refer page 26, para 26 of the compendium. Your lordships, in the case of Geeta Anand versus Tanya Arjun, the Honorable Court held that section 7 applies only where the cause of action is inherently matrimonial in nature. Your lordships, thereby arising from the rights and obligations between the spouses and not where the marriage is merely a background of the dispute. Your lordships, applying this test to the present case, it shows that the present case does not arise from a matrimonial relationship or an obligation between the spouses here, but it is between the independent third party and a spouse.
Don't you think matrimonial relationships are placed includes even extramarital relationship?
Kindly pardon, your lordships.
You are using the expression marital relationship.
Indeed.
You are referring to that aspect. Don't you think that the phrase marital relationship includes even extramarital relationship?
No, your lordships.
Why should we accept your argument?
Your lordships, the council submits that the marital here the respondent is the appellant alleges that the council seeks a moment of indulgence. Your lordship, the marital relationship is between two parties. However, if any third party interferes with their marriage, then it can fall within the it can fall within the family court's jurisdiction as to uphold the object of the family courts act, your lordships. Your lordships, the council seeks
We will simplify the question. Claim is, your claim is based on the fundamental fact that the plaintiff is a married woman having a consortium. That consortium has been broken down by virtue of interference by a third party. So the basis for your claim is a cause of action is a bundle of facts, isn't it? One of the main live nerve for your cause of action is that you are a married woman. Your marital life has been spoiled by other lady. If that were the case, marriage is the foundation for your case. Why should that it go to a family court is the question. Here also family life, marital life, consortium life has been spoiled is your case. That means plaintiff's case. That is the case. All marital matters should invariably go to a family court even though a relief is sought for against a third party. Why not it can be?
your lordships under section 9 of Hindu Marriage Act and under section 2 clause F of Protection of Domestic Violence Act, the court has defined the And the proportionality is met as it is not seeking to penalize it as an offense, but rather it is only compensatory in nature, thereby minimaling the restricting autonomy. Your Lordships, moreover, in the case of R. Rajgopal versus State of Tamil Nadu, the Honorable Court held that while privacy protects the personal and family life, it must be balanced against the rights of the other individuals, and unauthorized intrusion may attract the legal consequences as present in our case. Your Lordships, in the present case, the respondent's conduct, though it is consensual, was undertaken with the knowledge of subsisting marriage and directly interfering with the personal autonomy and interfere with the appellant's marital consortium rights. Your Lordships, therefore, such conduct cannot claim the protection under Article 21 as it is restricted. And secondly, it is most respectfully submitted that Article 21 does not extend to protect the acts of the third party that is done intentionally to disrupt a subsisting marital relationship. Your Lordships, liability arises when there is a valid marriage, intentional interference, and direct casual link between the conduct and the resulting harm. Your Lordships, in the case of Pinakin Mahipatra versus State of Gujarat, the Honorable Court had emphasized that the liability arises only upon the active and deliberate participation by a third party, as it was clearly established in the present case. Your Lordships, while Justice K.S. Puttaswamy versus Union of India recognizes the decisional autonomy, it does not grant an unfettered license to infringe upon the rights of the others. Your Lordship, similarly, in Shafin Jahan versus Ashokan, the freedom to choose a partner was upheld. However, such autonomy is confined to one's own choices and does not extend to interfering with the other's subsisting marital life. Your Lordships, therefore, the respondent's conduct being intentional and knowledge-based interference lies outside the scope of Article 21. Your Lordships, thirdly, the appellant most respectfully submit that the doctrine of alienation of affection imposes only civil liability which is compensatory in nature rather than penalizing that, and it seeks to redress the harm suffered by the aggrieved spouse. Your Lordship, this doctrine does not criminalize the consensual relationship, rather it imposes or it provides a remedy to the aggrieved spouse who had suffered the loss of companionship, psychological injury, reputational harm, and financial loss. In the Shobha,
All of them can be compensated by payment of money.
You're seeking monetary compensation, isn't it?
indeed, Your Lordship.
The appellant lost reputation, lost ownership right, all that. Can they be compensated with such payment of some money?
Your Lordship, the appellant suffered the harm, but if the husband of the appellant, if he is not comfortable anymore to live with her, she should be given some sort of compensation. She had suffered the psychiatric injury where she had to go through the treatment for several months, and also she had spent a lot of amount on it, and she had a child who is very small, and she had to grow her, and also she had to spend some money on her life, and that is why she is seeking the compensation. And moreover,
No client is the client seeking special damages or exemplary damages.
Your Lordships, kindly pardon.
We have a question whether your client seeks special damages or exemplary damages.
We seek exemplary damages, Your Lordships.
Don't you think the law as settled as on today, exemplary damages can be awarded only in two or three situations? Number one, when there is a breach of promise to marry. Number two, when there is a breach of honoring a check by court. In all other cases, extraordinary damages do not be awarded. How do you support your claim for extraordinary damages?
Your Lordships, the appellant had suffered the harm.
We are waiting for the completion of the sentence.
Your Lordship, she had suffered a harm which includes the loss of companionship, which cannot be measured. And
In terms of money,
indeed, Your Lordship.
but you are claiming huge amount of money.
Your Lordship, she had spent a huge amount on harm. She had claimed a lot of leave. She had claimed a lot of leaves for her treatment, and then she couldn't go she couldn't perform well in her work, which though she is eligible candidate, so that is why she was denied the promotion just because of the conduct of the respondent, and she had suffered the loss of salary which she may earn in future in case if she get a promotion, your lordships.
That's all. Again, when you are asking, when you are dealing with the point number 3, issue number 3, we want from you a clarification which we sought from for the first speaker also. Since you are dealing with the legal aspect involved in the issues 2 and 3, issues 3 is concerned, the issue is that whether a third party can be sued for entering into a promiscuous life with one of the spouses, which was considered by the Supreme Court in Saini Joseph as a fundamental right of privacy. If that were so, if that is their fundamental right, can the other person's wife sue for damages on civil side? We'll put it in a more lucid manner. The judgment of the Saini Joseph based on the premise that every man has a privacy, right to privacy, which is fountainhead under Article 21. Every man has a private life. Private life includes choosing his own sexual behavior. Sorry if we have to use this word, which is apt in this present context. In that context, a man and woman can choose their promiscuous way of mixing, which may amount to adultery also, but nevertheless, it is their fundamental right of privacy, which courts cannot punish them under a penal law. Okay, basically, the judgment relates to a decriminalization, 497, etc. That is one way. But the basis for that judgment, we are again asking you, the basis for judgment is recognizing the fundamental right of privacy to every man. If we recognize that right of privacy as a fundamental right, stretching that right of fundamental right to civil cases also, alleging that you have entered into our private life of wife and husband, you have taken away my husband, will this type of facts constitute a cause of action at all, is our point. That is the issue number 3 involved, isn't it? We have made it clear, our question. The very same fundamental right applies to criminal cases. Will it not apply to civil cases also? Is the question here. Of course, we have studied the Delhi High Court judgment, but we are sitting in the Supreme Court. We may approve or we may not approve the Delhi High Court judgment. Apart from that, you have to answer us. If we believe and we agree and admit that Saini Joseph recognizes the right of fundamental right of privacy and applied in that case only to criminal cases, why can't we apply the right of privacy, which is a fundamental right, to civil cases also? A man and woman choose in their right to live together. Maybe one of them is a married person. Still, it is their fundamental right. You cannot penalize them, you cannot punish them because decriminalization has come. Now, what is left is whether a civil liability can be attached to one of them or both of them is the question. Can we, when we say that it is a fundamental right is a constitutional right, isn't it? How can you choose a tortious liability to aim against one of them is the question. What is your answer?
Your lordships, the council submits that this case involves the Hofels theory, where there is a liberty and the corresponding one is a no right. Here, if the
we may, sorry for interrupting you, we may also remind you that in number of the judgments cited by you, means your team, The Supreme Court itself has held, so far as the marital connections are concerned, a husband is not a chattel to be stolen by other lady. Your own judgments have stated, a husband is not a chattel. అతను పశువు కాదు, is not a chattel, so that it is not a property to be stolen away by another lady. If that is the observation made by the Supreme Court, and Shiny's case is also there, recognizing it as a right of constitutional right of privacy, how and in what manner the present plaintiff can have a cause of action seeking for our indulgence and set aside the successive judgments, concurrent judgments of single judge as well as the division bench of the Delhi High Court.
Your Lordships, when the respondent has right to liberty or personal autonomy, it doesn't mean that she involves into the right of other person who is married and who has the same right of privacy to be in a marital relationship and shared household with her husband. Your Lordships, in Rajgopal versus State of Tamil Nadu, the court held that the matters relating to the marriage and family life are protected under the privacy, and unauthorized interference may give rise to legal consequences, thereby reinforcing the privacy must be balanced against the right of the others. Your Lordships.
Right to the appellant when she comes to the court, don't you think she must also come with clean hands?
Your Lordship.
Alleging violation of privacy. Have you not violated privacy? By accessing all the email?
The council differs this, Your Lordship, because the appellant doesn't have an intentional interference into the privacy of the respondent, but the respondent had this intentional interference and the wrongful conduct where she influenced the appellant's husband to come out of the marriage and be in a relationship with the respondent, and it is clearly evident from the annexures, Your Lordship.
One more academic point of view, because you owe a responsibility to answer and foresee the consequence if we allow this special leave petition. The adverse consequences that may have also you have to answer. Let us stretch this example to another case. A wife and husband are both cunning. They choose a innocent girl who is rich and alone. The wife sends her husband as a prey, and he develops intimacy, saying that he is not having good wife, she is torturing him in all means. That lady, third party, believing him and slowly develops an intimacy exceeding some bounds. Now this woman comes and says that you have advised my husband, you pay some crores of compensation. Can it be not misutilized if we have to allow this special leave petition and make it as a precedent?
Your Lordship's doctrine of alienation of affection, it recognizes the intentional interference into the marriage. It punishes the intentional interference into the marriage, Your Lordship. Here, in the example cited by Your Lordships, there is no intentional interference into the subsisting marital relationship, Your Lordships. However, in the present case that we are dealing, it has an intentional interference from the respondent to enter into the subsisting marital relationship with a malicious intention, Your Lordships.
In the example cited to you is also the third party knows that he is a married man. It is not, he has not hushed up anything. The example it is stated that my wife is a cruel lady. I am not getting any sort of physical relationship or emotional relationship with her. In that manner, he gained access to the third lady. So third lady knows that this man is a married man. Still developed because a constant goading and persuasion resulted in that example. So how can we say that the third party did not know anything and did not interfere? So our question is, will it not create some sort of opening floodgates for this type of litigation, which is based purely on emotional relationship between consortium, turning it into a civil dispute and making it a tortious liability against a third party. You owe a responsibility to answer that question also. You are the first counsel to ask this type of relief. Hmm?
Your lordships, while there are negative consequences, recognizing uh, some act or a remedy, we cannot neglect the rights of the appellant to marital consortium where a other party or a third party entered into her relationship and taking away her husband from her with a malicious intention. We cannot neglect the rights of the appellant also, your lordships. Your lordship, the council seeks permission to proceed with the argument. Much obvious, your lordships. Thirdly, the appellant most respectfully submits that the doctrine of alienation of affection imposes the civil liability. Your lordship, this doctrine does not criminalize the consensual relationship, rather it provides a remedy for the loss of companionship, emotional, psychological harm and reputational injury. In the case of Shobha Ram versus Tika Ram, the wrongful interference with the marital relationship was recognized by a tortious wrong, as a tortious wrong. Your lordships, further, in the case of Maneka Gandhi versus Union of India, lordships kindly refer page 49, para 40 of compendium. Your lordships, here the Honorable Court held that the personal liberty is subject to just, fair and reasonable restrictions. The present restriction here satisfies this standard as it merely compensates the harm rather than imposing the penal consequences. Additionally, your lordships, in the case of K. Srinivas Rao versus D.A. Deepa, it was recognized that the mental anguish and disruption to the marital harmony constitutes an actionable injury. Your lordships, the doctrine is narrowly tailored that in such a way applying only the intentional and wrongful interference, knowledge-based interference, thereby maintaining a balance between the individual autonomy and relational rights of the appellant. Your lordships, the council answers your previous question in the same way, that there should be a balance between the rights of appellant as well as the individual autonomy. Your lordships, therefore, imposition of such liability is proportionate and constitutionally valid restriction under Article 21. Your lordships, with the due lordships permission, the council would move on to the prayer. Much obliged, your lordships. Wherefore, in the issues raised, arguments advanced and authorities cited, the council on behalf of the appellant humbly pray before this Honorable Supreme Court of India that it may be pleased to adjudge and declare that thought of intentional interference with the marital consortium survives in the Indian civil jurisprudence, notwithstanding the decriminalization of the adultery, and hold that the civil suit for damages against the third party for alienation of affection is maintainable and does not fall within the exclusive jurisdiction of the Family Courts under Family Courts Act. Declare the imposition of civil liability on the third party for intentional interference with the subsisting marriage does not violate the fundamental right to privacy under Article 21 of the Constitution, and set aside the orders of this Honorable High Court rejecting the plaint and restore the appellant's suit for adjudication on merits, and or pass any other order, direction or relief that this Honorable Court may deem fit in the interest of justice, equity and good conscience.
Then the council you have only one. You want the judgment given by the single judge, or do you want the order for compensation?
Your lordships, the council seeks to allow the plaint and allow the plaint to continue, allow the plaint, thereby allowing the appellant to
You want us to recognize that there is a cause of action.
cause of action in the civil courts, your lordships.
What about damage?
it should be dealt on merits before the it will be dealt by the honorable it will be dealt by the trial court on merits, your lordship. Trial court, your lordship. Trial court.
Thank you. Any other submissions by the alert counsel?
Uh, Nothing, your lordship.
Thank you very much.
It's an honor to argue before this bench, your lordships. Much obliged.
Yes, respondent side ready? Yeah. You are the first speaker, we suppose. You will be delving on?
Speaker 1 and speaker 2.
Okay.
I will be stating issue 1 and 2, and I will be stating co-counsel state issue 3.
Issue 3. You will be dealing with the 1 and 2 issues. Good.
Honorable court, given permission and address Tuesday. My lords, before addressing the rights, the respondent respectfully raises preliminary questions on maintainability of this special petition. My lords, Jurisdiction under Article 136 is extraordinary and discretionary. This honorable court generally does not interfere with concurrent findings of lower courts unless there is a serious miscarriage of justice or an important question of law. In the present case, both the single judge and the divisional bench have consistently held that suit has no valid cause of action and falls within the jurisdiction of the family court. My lords, the petitioner has not shown any error, injustice, or substantial question or legal question of law that requires this court's interference. However, my lords, without prejudice to this objection, the respondent will proceed to address the issue on merits. With your permission, my lords, can I state the facts?
In brief.
In brief. Or else I'll just quote one point of the appellants, my lord. Much obliged, my lords. My lords, I want to state a fact, my lord. Here, every act that caused the petitioner's harm was Mr. Gupta's autonomous act, not the respondent's. My lords, this court in Shafin Jahan was my lord. Yes, my lord. No harm being caused. Petitioner's harm. Like petitioner has filed a case regarding the harm. Yes. No, my lord. I'm stating that they have stated like that. They have stated like that. Yeah, yes, yes. It needs to be cast. Much obliged. My lords, this honorable court in Shafin Jahan versus Ashokan held that the right to choose one's partner is a fundamental right. Mr. Gupta exercises that right. The respondent cannot be held liable for Gupta exercising his constitutional right. My lords, I just want to move, with your permission, issue 1. Issue 1. Much obliged, my lord. The issue 1 is whether the common law of tort of intentional interference with marital consortium survives as a valid cause of action in the civil jurisprudence of India, or whether it stands implicitly overruled by the decriminalization of adultery. My lords, it is humbly submitted that this present case is not strictly about adultery. The principle laid down in Joseph Shine versus Union of India is broader. The state cannot impose legal sanctions on consensual relationships between adults. My lords, the petitioner's attempt to characterize the present case as intentional interference with marital consortium is fundamentally flawed. The claim is an effort to convert a consensual personal relationship into a legal wrong, which is neither supported by Indian law nor consistent with the constitutional principles under Article 21. My lords, the constitutional foundation of such claims, treating marriage as conferring control over a spouse's choice, has been expressly rejected as violative of Article 14, 15, and 21. My lords, recognizing this tort would indirectly penalize such relationships which are protected under Article 21. My lords, the entire foundation of this tort rests on the proprietary view of the marriage, that one spouse has a claim over the affection and fidelity of the other. My lords, marriage does not create ownership over emotional choices. However, it follows logically that no enforceable duty arises against third parties to preserve such a relationship. The respondent, being a stranger to the marriage, owes no legal obligation to the petitioner. My lords, the law does not impose a duty on individuals to safeguard the marriages of others. Without a legal recognized duty, the foundation of any tort claim collapses at the threshold. My lords, the very foundation of this tort has been declared unconstitutional. When the constitutional basis, of a cause of action is removed, the cause of action itself cannot serve. I just want to mention one point, my lord. Here, the cause of actions are not of her own. It is by Mr. Gupta. My lords, the Article 21, which is right to privacy, dignity, and personal autonomy, even in Honorable
We are
Justice.
pausing for a moment.
Yes, my lord.
The plaintiff is not questioning your fundamental, so-called fundamental right of privacy under Article 21 recognized by the Shiny Joseph. You may have your own fundamental right of privacy, but you have no right to indulge into the other's privacy is their question.
Miss Singh, actually, she didn't indulge.
See, again, we may say that recognizing fundamental right of privacy, a person can choose his own private life so long as every man's right stops at elbows, isn't it length? You cannot violate others' privacy right also at the same time.
Indeed, my lord.
The plaintiff says that while exercising your so-called fundamental right of privacy, you have indulged into my family life. How you answer that one?
The council seeks.
How you take advantage of Shiny Joseph in such an example? Will you not owe a responsibility to answer that if Shiny Joseph is extended to even civil cases, a promiscuous life leading by wife, woman and man, and there will be no moral society at all. At least some civil liability is not fixed on them. What do you say?
Indeed, my lord. My lord, here, initially when Vidyavati Singh joined in the company of Mr. Gupta as a strategic consultant in January, till they were in relationship. Relationship started from October, my lord. Actually, initial 8 months there was no relationship between them, and there was a professional relationship. So there was a professional relationship.
Because it did not start immediately.
Because intention is not there, my lord.
Document is that because it did not start immediately. So client is not come out. So it will start immediately. Love at first sight and fight at first sight.
But as per the appellant's,
It was the learned counsel to kindly also remember that there is an institution of marriage, an institution of family. How it is going to affect those two institutions which are part of our family?
yes, my lord, the council answer the questions, my lord, with your permission. My lord, actually with the Gupta's consent only, they were in relationship, my lord. If actually initially both the
Your client is not a minor. She was, we were told by facts that she was 26 or 28 years old
28
and working in a prestigious organization, drawing huge salary. She has the right of discretion in her mind. When one man has moved close to her and office record shows that that man is a married man also, all these facts will tell. So would she not have liability or responsibility to be careful to move close to them, that man? so that to not to spoil the life, marital life of other lady.
The council seeks
Can you
permission
just
to
take
answer.
advantage of Article 21 in this regard and sign Joseph?
The council seeks permission to answer the. My lord, here, the initial phase, the relation between Mrs. Gupta and Mr. Gupta, they were not that normal. Because dominant relationship is there. Mrs. Gupta has a dominant relationship over Gupta. So he might have uh, leaned towards Vidyavati Singh.
Learned counsel, uh, please bear in mind that if the dominance is an important factor to be considered, 99% of marriages don't work. In fact, marriage itself says that the lady can dominate. You are free for free marriage. Afterwards, you are at the mercy of somebody else. Maybe the type of life which you are envisaging is a dream. Please go ahead.
Sorry. With your permission, I will just continue. My lords, in the present case, the appellant's own evidence, messages, and admissions clearly show consensual emotional and physical relationship between Mr. Gupta and the respondent, with no coercion involved. My lord, secondly, in Justice K.S. Puttaswamy versus Union of India, 2017, the Supreme Court affirmed that intimate personal relationships fall within the decisional autonomy and privacy. Imposing civil liability of 5 crore based on private communications would amount to judicial intrusion into a protected private sphere. My lords, therefore, imposing liability on the respondent would amount to indirectly penalize a consensual relationship, which is contrary to the constitutional principles laid down in Joseph Shine. My lords, thus the alleged.
We want to penalize. What is it you want us to do? Encourage the relationship. You are asking us not to penalize. Suppose the law agree. What is it we should do? Simply keep a blind eye and see that it happens. There is no remedy at all.
Actually, my lord, there should be cause of action, my lord. Cause of action means duty of care, direct interference. If Gupta's consent is not there, if she is only interfering, then there can be an action, my lord. Here, the action is between both sides, and the consent is between both sides. They have personal autonomy, as stated from the Honorable Court.
In a civil suit, the plaintiff under Order 7 is stated to be dominus litis, is not it? If cause of action arises against so many persons, in some cases, particularly in money cases, he can choose only one person to seek for relief. But this principle is not applicable in all cases. But in a suit for money, if money can be asked against various persons, it can be asked against one person also in certain circumstances, particularly in this nature. You are saying that Mr. Gupta has made advances and your client, okay, she has conceded and therefore he is also liable, but my party alone cannot be penalized by a civil suit. You are saying that. But the plaintiff has a right to choose his own defendant, isn't it? That right cannot be questioned. But the question is whether there is a cause of action, actionable cause or not is the question here. You are saying we could understand that because of the signage Joseph, Article 21 recognized the right of privacy. Under that umbrella, no civil suit also is maintainable. That is what your argument, isn't it?
Yes, my lord.
Anything more?
Yes, my lord. With your permission, I will just. My lord, here no tort arises without a legally recognized duty. The respondent, being only a strategic consultant, owed no legal, contractual, or fiduciary duty to the appellant or her marriage. Personal messages like leave her do not create enforceable obligations. Hence, no liability arises. My lords, Indian law does not recognize the tort of alienation of affection or interference with marital consent. Recognizing such a claim would amount to judicial legislation and conflict with the constitutional values of autonomy and privacy. My lords, I just want to state here one point, my lord. Here, influence is the only word. If civil liability can be claimed, then in every home, neighborhood, relatives, anyway, so there will be a lot of cases.
What is the definition of tort? You are saying that Indian law does not recognize this type of tortious liability. What is the definition of tort?
The civil wrong, my lord.
Civil wrong. Civil liability, is it not a civil liability on the part of one person not to interfere with the private marital life of another person? Is it not? Is it not a civil liability?
But she has
Breach of civil liability.
there is no
Even if we take the rudimentary principle or definition of the tort, tortious liability arises out of the breach of a civil liability, is not it? Which can be redressed to an unliquidated damages. She claims unliquidated damages now. Of course, some bills are to produce mental doctor treatment, etc. That's a different aspect. So, would you say that no cause of action under tortious act, law of torts is there in this case?
counsel seeks permission to answer. My lords, here the cornerstone of the tort liability is duty of care, which is entirely absent here, my lord, because there is a recognized legal relationship. The law imposes an obligation to prevent harm. In the present case, the respondent is a stranger to the marriage. She has no legal obligation towards the petitioner. My lords, here breach of duty, there is no breach of duty, my lord, because the communication between...
We remind you again and again that your facts would tell that this lady knows that that man is a married man.
Indeed, my lord.
And she is not a minor, as we reminded you. Is it not sufficient to attract the civil liability, tortious liability against her?
For a tortious liability, there should be a cause of action, direct cause of action, my lord. Here,
Learned counsel,
my lord, indeed.
what is the relation between Mr. and Mrs. Gupta?
Husband and wife, my lord.
Is it not contractual? Yes, sir. No.
Yes, my lord.
What is the relation between Singh and Mr. Gupta?
Employer.
Well, if it is only
Sorry.
employee, so much of time.
Sorry,
not
strangers.
there. Is it not contractual? Both of them have come to an agreement to live together. Am I right or wrong?
Indeed, my lord.
So there is a contract. That means Singh and Gupta, both of them entered into a contract whereby they want to induce the breach of contract between Gupta and Mrs. Gupta. And inducing breach of contract is a tort. That's what we learned when we were students. What is your...
Indeed, my lord. But tort law does not penalize moral wrongs. Personal relationship.
You are inducing breach of contract.
Yeah.
The Singh is inducing breach of contract subsisting between Mr. and Mrs. Gupta.
My lord, here novus actus intervenience is also coming into the picture, my lord. Because Gupta chose to respond and continue the relationship, and he chose to leave the marriage.
Who is responsible for he leaving the marriage?
Because these were independent and voluntary decisions, my lord. These are all conscious decisions. Yes, my lord. Yes, my lord. Yes, my lord. In Pinakin Mahipatra Rawal versus State of Gujarat, the Supreme Court merely observed that such concept exists in theory, not as an established cause of action. My lords, even in Shelly Mahajan versus Bhanushri Bal, the court only held that claim may be examined at trial, not that liability is conclusively established. The law remains uncertain and undeveloped. My lords, the tort is not only unconstitutional, it has been abolished in virtually every common law jurisdiction, including United Kingdom, Canada, Australia, majority of the USA. The reason is it treats spouse as a property, which violates dignity, leads to speculative damages. My lords, the tort must be abolished as it treats a spouse as a property whose affections can be stolen undermining individual autonomy and dignity. It also demeaning, particularly to women, and leads to speculative and disproportionate damages. My lords, here causation is essentially a tort law. Mr. Gupta, an educated and financially independent individual, voluntarily engaged in the relationship and made conscious decisions, including leaving the matrimonial home. My lords, therefore, the breakdown of marriage cannot be attributed solely to respondent. Under the doctrine of novus actus interveniens, his independent decisions break the chain of causation. Yes, my lord, because he also intervened in between. If a person makes independent and voluntary decisions. My lords, the appellant admits prior disagreements regarding parenting, career priorities, and dominance in the relationship. This indicates that the marriage was already strained. Therefore, the respondent cannot be held responsible for its breakdown. My lords, allowing such claims would open floodgate of litigations, encouraging scrutiny of private relationships and communications, which leads to judicial intrusions into private relationships. As seen in this present case, where 4,500 private messages are relied upon. My lords, this would lead to moral policing and violate the right to privacy. Hence, such a tort must not be recognized.
So why should encourage husband immoral?
Pardon, my lord.
Why should encourage husband immoral?
Nothing like that. My lord.
You are telling the police is no fault, and you are asking them that you should not be encouraged.
Yes, my lord.
Go ahead.
Yes, my lord.
We have a right to interfere. We are interfering. Don't claim damages.
As in the constitutional institutions. Much of this. Here, the essential elements of tort are clearly not satisfied. There is no duty. The respondent owes no obligation to the petitioner. Here, there is no breach. Communication between consenting adults is not unlawful. There is no causation. Mr. Gupta's actions were voluntarily and independent. There is no legal damage. Emotional distress alone is insufficient without legal injury. My lords, the law cannot reduce an autonomous adult to a passive victim of influence. My lords, the petitioner's claim seeks to impose liability where no duty exists, penalize lawful conduct, and override individual autonomy. My lords, the alleged tort lacks legal recognition and constitutional validity, and therefore no civil liability can arise against the respondent. My lords, in a country where societal norms often clash with personal choices, the court's message is blunt. Legality does not bind to societal discomfort. My lords, I would like to continue with issue 2 with your permission, my lord. Much obliged. 1 and 2, my lord. My lords, issue 2, whether a suit for damages against a third party falls within the exclusive domain of Family Court under Section 7 of the Family Courts Act 1984, thereby bearing the jurisdiction of civil courts. My lords, it is respectfully submitted that the present suit is not maintainable before the civil court, as it falls within the exclusive domain of the Family Court under Section 7 of Family Courts Act 1984, thereby bearing civil court jurisdiction under Section 8. My lords, jurisdiction must be determined by the substance of dispute, not in its form. Both the single judge and division bench of Honorable High Court of Delhi correctly held the suit to be not maintainable. My lords, in Vijay Kumar Bhatte versus Neela Bhatte, Honorable courts have held that the true nature of the claim governs jurisdiction. The present claim is rooted in marital consortium, breakdown of marriage, and emotional injury arising from spousal relationship, all inherently marital issues. My lords, here we have to note one point, my lord. The special laws will always prevail over general laws. Family Courts Act 1984, Hindu Marriage Act 1955, etc. These are all enacted as special laws. My lord, Section 7 must be interpreted purposely. The Act was enacted to provide a specialized forum for all disputes arising. Pardon.
For your convenience, we will refer the arguments raised by the other side for your convenience and brevity, saving of the time. One of the main arguments in respect of issue number 2 by the Land Council is that the relief now sought for by the plaintiff it cannot be given by the family court, even if we extend the section 7 to it. According to them, section 7 is meant for a suits inter se between, that means inter se means between the wife and husband, seeking for partition of the property, seeking some maintenance, seeking for maintenance to the wife and children, etc. type of reliefs. So section 7 never envisaged a relief of the nature of asking damages or compensation against a third party who is not a party to the marriage. That is their argument. How do you say that now the family court alone is the forum for the plaintiff, even if cause of action is there? Do you say that section 7 really applies to the present case on hand?
Yes, my lord. Indeed, my lord. Counsel seeks permission to answer. Here, the petitioner's claim is entirely based on alleged interference, my lord, with marital consortium and breakdown of marriage and emotional and psychological harm arising from a relationship. But these are inseparable from matrimonial status and fall squarely within the family court, my lord, family court jurisdiction. Yes, my lord.
Suits between the parties of a marriage, that is what section 7 specifically tells.
Indeed, my
Third
lord.
party is not a party to the marriage, maybe a party to a consensual life, that is a different aspect. Suits between the parties to a marriage is the phraseology used in section 7. Now, how can you bring this present suit into the purview of section 7? That is what their argument. We want to just refresh our
Yes, my lord.
to
Indeed.
answer.
Indeed, my lord.
Please go through section 7 and
Yes, ma'am.
answer in which ambit or which reason how the suit falls.
Here, section 7.
Explanation is sufficient.
Yes, ma'am. Section 7 have and exercise all jurisdiction exercisable by any district court or subcourt. The suits proceeding referred to in these subsections are suits and proceedings in the following nature. Like suits or proceedings for an order or injunction in circumstances arising out of a marital relationship. Indeed, my lord.
Section 7.
Section 7D, a suit or proceedings for an
Explanation. Section 7 explanation. Family
Yes, my
Courts
lord.
Act.
Yes, my lord.
Section 7 jurisdiction.
Yes, my lord. Jurisdiction.
Explanation.
Yes, my lord.
Explanation.
Yes, my lord. Indeed.
Reading please.
Yes, my lord. Jurisdiction. The choosing. The suits and proceedings referred to in this subsection are suits and proceedings. A suit or proceeding between parties to a marriage for a decree of nullity
Stop there. Between the parties to the marriage means what?
between husband and wife, my lord.
Your claim is a party to the marriage. Relief is against your party, not against her husband. When you say section 7 is an obstruction for filing a suit in a civil court, that is their argument. What is your answer?
Indeed, my lord. The council seeks permission to answer. Section 7 actually is jurisdiction regarding the dispute regarding matrimonial affairs, my lord, matrimonial issue. Here, the subject, the appellant has directly has raised the objection regarding the civil liability to the respondent, my lord. But here, respondent is not directly interfered with appellant. So the issue is between Mr. Gupta and Mrs. Gupta, my lord. So the relief should be sought with Mr. Gupta, but not with Vidyavati Singh.
See, your argument is that she could have claimed against her husband but not against my party.
Indeed,
That
my
is a
lord.
different context. But she now claimed relief against your party. Whether she should go to the family court or whether she should can go to a civil court is the point now we are discussing. Issue number 2 you are dealing isn't
Yes,
it?
my lord.
How you defend your argument that civil court is barred and only the family court alone is competent, if at all there is a cause of action? How you defend your point?
Indeed, my lord. Here, merely respondent is a third party does not change the essential nature of the dispute, my lord. The injury claimed by the appellant is the loss of her husband's affection and breakdown of marriage. That's why she can sought the relief in the family court, my lord. Yes, my lord. With your permission, I'll just start this. My lords, the facts clearly show that Mr. Gupta has already filed a divorce petition on the grounds of cruelty under section 13, 1IA of Hindu Marriage Act 1955 before the family court. Simultaneously, the appellant has filed a civil suit claiming damages based on the same set of facts. My lords, here Rajesh Sharma versus ORS versus State of Uttar Pradesh 2017, it highlights misuse of matrimonial laws to rope innocent persons and cause harassment. The petitioner is misusing tort claim to harass an innocent third party with the above claims, my lord. My lords, allowing civil courts to entertain such suits would lead to parallel proceedings and conflicting decisions. This amounts to splitting a single matrimonial dispute into multiple proceedings, which is impermissible, leading to inconsistency. My lords, the same marriage would be examined in family court for a divorce and marital relief, in civil courts for damages. This duplication is precisely what the Act seeks to prevent. My lords, in IFCO Tokyo General Insurance versus Pearl Beverage, honorable courts cautioned against parallel adjudication of the same underlying dispute. Here, the entire dispute arises from marriage, alleged interference, and breakdown. Therefore, it falls under the family court. My lords, the object of the family courts is to ensure that all family and matrimonial disputes are adjudicated in a specialized forum. Allowing civil courts to entertain such claims would defeat the purpose of the Act and dilutes its effectiveness. My lords, since the plaintiff does not disclose a valid cause of action and the dispute falls within the matrimonial domain, the Honorable High Court was correct in rejecting the plaintiff at the threshold. The dismissal of the appeal is therefore justified. My lords, recognizing civil jurisdiction would expand tort law into matrimonial domain, leading it to floodgates of litigation where every marital dispute is converted into damages claiming against third parties. This would undermine the specialized conciliatory framework of family courts. My lords, importantly, the present case is not about adultery under IPC, but about marital breakdown, which is already addressed under the matrimonial law. The appropriate remedies lie in divorce, maintenance, and alimony, but not civil damages. My lords, the present suit, though framed as a civil claim, is essentially matrimonial in substance, falling within the Section 7 of the Family Courts Act 1984. Consequently, under Section 8,
Civil Procedure Code, the other side argues that every court of civil nature has jurisdiction to try these suits of civil nature unless their jurisdiction is either expressly or impliedly barred. Their argument is that neither expressly nor impliedly this present suit is barred. Express provision, there is no express provision, and which Section 7 has no application is their argument. We have referred to you the phraseology, a suit between parties out of marriage, that is one aspect. Implied bar, there is no other forum or a tribunal constituted to deal with a suit of this nature. So there is no implied bar also. Then how can you say that the present suit is barred in a civil court. They are taking aid of section 9. Section 9 is very powerful section, isn't it?
Indeed, my lord.
Every court of civil nature shall have the jurisdiction to try the suits of civil nature unless their jurisdiction is either expressly or impliedly barred. There must be either express bar or by necessary implication it must be barred. According to them, in either way it is barred.
Indeed, my lord. Because the case directly falls under the section 7 like jurisdiction. So, yes, ma'am. Because it is in matrimonial in nature, my lord. Section 7. Yes, ma'am. Indeed. Co-counsel will start proceeding. Issue 3, my lord. Much obliged, ma'am.
My lord, the council seeks permission to address issue 3, my lord. Much obliged. My land Kev Council has laid the foundation of the law of torts. I rise to address the constitutional heart of the issue by addressing issue 3 in this cause, that is, whether the imposition of civil liability on a third party for engaging in a consensual relationship with a married person constitutes an infringement of the fundamental right to privacy and personal liberty guaranteed under Article 21 of the Constitution of India. My lord, I want to divide this into 4 segments, my lord. My first segment is the death of chattel theory. My second segment is privacy and intimate association. My third segment is proportionality and moral policing. My fourth segment is correct balancing of rights. My lord, moving into my first segment, post Josephine jurisprudence. Counsel submits that the appellant's claim for loss of consortium against a third party is a ghost of the colonial past. In Josephine versus Union of India, this Honorable Court struck down Section 497 IPC, famously declaring that a husband is not a master of his wife. By extension, a wife is not the owner of her husband's affection. To allow a civil suit for alienation of affections is to judicially revive the chattel theory, where a spouse is treated as a piece of property that can be stolen or mislaid. This is inherently derogatory to the dignity of the individual under Article 21. My lord, moving on, the doctrine of adult agency. Mr. Abhinav Gupta, who is the managing director of a global logistics firm, he is a high-functioning adult with full legal capacity to argue that he was emotionally subjugated by a 28-year-old consultant is to strip him of his constitutional agency. If a marriage fails, the accountability rests with the spouse who took the vows. The respondent owes no legal duty of care to the appellant. Any harm suffered by the appellant is a direct result of her husband's choices, not a tortious act by the respondent. My lord, moving on with my second segment, privacy and intimate association. Briefing it, the sanctity of the inner sanctum. Under Justice K.S. Puttaswamy versus Union of India, it is mentioned that right to privacy is a part of the Article 21 and includes decisional autonomy. Any restriction on privacy must pass 3-part test, which is legality, legitimate aim, and proportionality. My lord, all these three limbs fail in this case, my lord. Coming to legality, there is no recognized tort exists post Josephine, hence no legal basis for liability. Coming to legitimate aim, the state cannot use marriage to restrict consensual adult choices as rejected in Josephine. Moving on with proportionality, imposing a 5 crores for a consensual relationship is excessive, punitive, and creates a chilling effect on personal autonomy. My lord, moving on, my lord, protection of private correspondence. The appellant case mainly relies on 4,500 encrypted iMessages accessed via a shared laptop. These represent the most private thoughts of two individuals. To allow a suit based on the accidental discovery of such messages would incentivize digital vigilism within marriages. The law of torts cannot be used as a tool to bypass the constitutional right to private communication. My lord, moving on with my third segment, which is proportionality and moral policing. My lord, let's differentiate between this constitutional.
Led counsel, since you are mostly relying upon Puttaswamy at this stage, while agreeing to some extent that in that judgment it has been held that marriage, mere marriage, cannot restrict a consensual relationship. Yes, this sentence has been used by the Supreme Court. Marriage cannot restrict the consensual relationship, subsequent consequence, consensual relationship with another lady or another man, in the context of penalizing them under criminal laws. That is what their main argument is. We will again repeat. Marriage will not or cannot restrict the consensual relationship outside the barriers of marital relationship. We cannot restrict their consensual relationship to penalize them under any penal code or penal laws. But at the same time, whether this consensual relationship, if it affects the private right or another woman, she is also a married lady and her marital life is affected, whether Puttaswamy can come to the rescue of this third party, whether in that sense it has been anywhere stated in the Puttaswamy judgment. It will not attach any civil liability also. In so many words it has been stated anywhere.
No, my lord.
Will you please bring it to our notice, because we have not today entirely read it. Anywhere it has been specifically held that it will not attach equally the civil liability,
No, my lord.
or left it as it was, dealing only with the decriminalization of consensual relationships.
Indeed, my lord.
You say that Puttaswamy, it was in so many words it was held that it was not attract the civil liability also. Honorable Supreme Court has held so. Understood what our question is?
Yes, yes, indeed, my lord. I see.
It will not attract the civil liability also. We will again tell you that Puttaswamy, it has been recognized a fundamental right of privacy. In the realm of right of privacy, two persons can lead to a consensual life also. We cannot penalize them under penal laws. There is no problem in recognizing that right as a fundamental right of privacy.
Indeed, my lord.
Whether this fundamental right of privacy right can be used to go to further extent and say that I can even interfere into the marital life of another woman and another woman cannot sue me for compensation or special damages, whatever it may be. If we are posing you an academic question, if we recognize this consensual life as a license or right, equally, the married woman cannot seek divorce against him because he is even moving with another lady. Adultery is the first ground, isn't it?
Indeed.
Under section 13.
Indeed.
Because the husband can file a counter stating that Puttuswamy recognized my right of consent as a private right of privacy. It cannot be a ground for divorce also, he may ask, isn't it? He may argue.
Indeed, my lord.
So can we stretch this right of privacy only to criminal cases or even to the extent of all civil cases including divorce petition filed by the wife? Understood the example?
Yes, ma'am.
Husband is leading a debaucherous life. Wife filed a petition for on the ground of adultery, divorce petition. Husband argues that Puttuswamy recognized my right of privacy as a fundamental right. You cannot file a divorce case. Can he take? That is also there, the right of privacy arises, isn't it?
Indeed, my lord.
Puttuswamy case is applied. Can it be applicable? If it is not applicable there, why can't be in the present case? Is the question.
My lord, for for anything to be happened, there should be a mutual consent between the two parties, my lord. In this case, my client, who is the respondent, Miss Vidyavati Singh, she is unmarried, my lord. Coming to Mr. Gupta, he is married. He already had his love life. He already had everything in his life. Whereas my client, she's first like she's having her first love. What do we call it as? Like, Mr. Gupta should be more precise about his moral values rather than my client.
Moral standards are different from husband and wife and also.
Anyways, my lord, in this case, he has some contract with his wife, my lord. So, Mr. Gupta should be. Mr. Gupta should stick to more of his moral values, my lord. And to conclude, legal laws will prevail over all moral laws, my lord. So, I continue with my much obliged.
We understand the difficult proposition you are right having appreciate this work.
Much obliged, my lord. My lord, as I already mentioned about protection of private correspondence, my lord, I I like to differentiate between constitutional versus social morality. The opinion claim is rooted in social morality. The idea that homewreaking is a sin. However, this court has held that constitutional morality must be the sole guide. The law cannot punish a third party for breakdown of a marriage when the state itself has decriminalized the act. The backdoor entry via civil litigation to punish moral wrongs is a violation of the rule of law.
Husband being immoral is a violation of constitutional morality. However, linking morality of personal life with constitutional morality. You like the concept to kindly explain.
The law cannot punish a third party, my lord, for the breakdown of a marriage.
Bringing the concept of constitutional morality is not yet defined even by the Supreme Court, and saying that the personal irregularity of the part of the individual is constitutional morality. I think it is a lot of disjoint statements are being made. But
The floodgates of vengeful litigation. If this court recognizes this tort, it opens the door for spouses to use anyone, friends, therapists, or colleagues who influences a partner's decision to leave a marriage. The 5 crore demand is not compensatory, it's punitive and predatory. It seeks the civil death. It seeks the civil death of a young professional for an intimate choice, which is grossly disproportionate restriction on her right to life and livelihood. My lord, moving on with my fourth segment, correct balancing of rights is the differentiation between respondent's privacy versus Ms. Gupta's autonomy. My lord, the petitioner invokes her Article 21 rights to dignity, mental health, and family life as the basis for her claim. The respondent acknowledges that the petitioner has experienced significant distress. However, the respondent asserts that the proximate cause of this suffering lies with Mr. Gupta's autonomous decisions. The respondent contends that the appropriate constitutional analysis necessitates identifying the actual cause of the harm and the individual who has violated the rights at stake. The petitioner's Article 21 rights to dignity and family life were infringed upon by Mr. Gupta. As the party to marriage, he made solemn vows, chose to act on his personal emotions, disclose the relationship of his wife, abandon the matrimonial residence, and file for divorce. Each of these actions constituted a violation of the petitioner's Article 21 rights, not the respondent. If courts were to punish third parties for relationships, it would result in an invasion of private lives and transform courts into moral regulators of relationships, contradicting constitutional principles. My lord, I want to conclude, my lord. The respondent submits that the appellant is attempting to turn the clock back on Indian family law. A marriage is a partnership between two equals, not a bond of ownership. The respondent is a stranger to marriage and owes no legal obligation to sustain it. To allow this suit would be to sacrifice Article 21 at the altar of an archaic and patriarchal tradition that the law has already outgrown. My lord, can I submit the prayer, my lord? Wherefore, in the light of issues raised, arguments advanced, and authorities cited, it is humbly prayed that this honorable court may be pleased to dismiss the special leave petition of 2024 and affirm the judgment and order dated June 10, 2024 of the Division Bench of the High Court of Delhi, as well as the order dated May 15, 2024 of the single judge rejecting the petitioner's plea. Declared that the common law tort of intentional interference with marital consortium does not survive as a valid cause of action in the civil jurisprudence of India and stands impliedly overruled by the decriminalization of adultery as declared by this court, Honorable Court, in Joseph Sain versus Union of India. declare that the suit for damages against a third party for intentional interference with marital consortium falls within the exclusive domain of the Family Code under Section 7 of the Family Codes Act 1984, thereby barring the jurisdiction of civil courts, and affirm the concurrent findings of the court below on this question. Declare that the imposition of civil liability on a third party for engaging in a consensual relationship with a married person constitutes an infringement of the fundamental right to privacy and personal liberty guaranteed under Article 21 of the Constitution of India. Award costs of these proceedings throughout against the petitioner, and pass any other order, direction, or relief that this honorable court may deem fit in the interest of justice, fairness, equity, and good conscience, all of which is humbly submitted, my lord. Much obliged.
Senate Council, you have 5 minutes for your rebuttal.
Your Lordships, the council would submit the council seek permission to answer for the opponent's rebuttals. Your Lordships, the opponent council have stated that since no statute recognizes the tort, it cannot exist. This is incorrect, Your Lordships, because Indian tort law is a judge-made common law and courts have consistently recognized torts. Therefore, the absence of legislation does not negate the liability. Your Lordships, further reference, previously as I have mentioned in the arguments, for the purpose of understanding to the Lordships and to the opponent's counsel, the council seeks permission to kindly refer para number 15 and page number 12 of the compendium.
You will go to your written submission. Go ahead with your order.
Indeed, Your Lordships. Lordships, in this case, in Pinakani case where it was clearly stating that the successful prosecution of such actions for alienation of affection must be the laws of marital relationship, companionship, assistance, and laws of consortium, etc. As such may not be sufficient, but there must be a clear evidence to show active participation, initiation, or encouragement on the third party, that she or he must have played a substantial part in inducing or causing one spouse loss of other spouse affection. Your Lordships, by these statements, it is clear from the evident and record that from the MOOT proposition, page number 6 of the MOOT proposition and para number 4, where it was clearly stated by the opponent counsel respondents that Ms. Vidyavati Singh that the campaign was buttressed by continuous clandestine communication via encrypted channels beyond the customary business hours, whereas the opponent counsel mentioned that it was strictly in a business development. So it is clear from the record that it was beyond the customary business hours, including late night messages from 10 p.m. to 2 a.m. with sexually explicit content, deliberate concealment through iMessages, disappearing messages future. So it is clearly establishing the fact that the respondent is manipulative, because by these statements we can establish she is manipulative in inducing by active participation, Your Lordships. Further, Your Lordships, the opponent counsel have stated, the opponent counsel have argued that Mr. Gupta consented voluntarily, however, tortious interference does not require coercion. But Intentional inducement or encouragement with the knowledge of marriage is sufficient to establish the liability or lordships. Because your lordships, kindly give 1 minute. Your lordships, therefore, the opponent counsel was also stated that the consent between two, where the respondent have stated that in the present case, in our impugnant case, I am stating the counsel stating that the respondent had a full knowledge of subsisting marriage, encouraged separation, and manipulated emotional dependency. Therefore, consent between two individuals doesn't negate wrongful interference with the legally protected marital relationship of another. So, with your lordship's due permission, I have concluded my rebuttals. Now, the other rebuttals will be continued with.
Your Lordships, adding to the points of my co-counsel, I would submit to the Honorable Court that respondents had stated that family courts had jurisdiction under Section 7, Explanation D. However, the appellant submit that under Section 7, Clause 1, Explanation D, it is clearly stated that it is a suit or proceeding against claiming the seeking the injunction or an order, which in the present case the appellant seek the remedy from the civil courts, and also it is in the where there is a phrase that the disputes arising in a matrimonial relation, circumstances arising from a dispute in a matrimonial relationship. However, the appellant submit that here the claim is here the cause of action is independent civil action, and your lordships, in the page 18 of the memorial of the respondent, it is clearly stated that no state institution, including the civil courts operating under civil law, can be utilized to penalize the consensual adult relationship. However, your lordships, the appellant seeks the damages which are compensatory in nature and not penalizing the conduct. Your lordships, the council seeks a minute of extension, your lordships. Much obliged, your lordships. Your lordships, in page 16 of the memorial of the respondent, they stated that the parallel proceedings cannot continue. However, in the present case, there is no parallel proceedings. Here, the husband has instituted the suit in the Delhi High Court, claiming the asking for a divorce on a basis of cruelty. However, in the present case, we seek the damages from the civil court from the respondent. Here, the parties are different, relief is different, and cause of action is different, which is arising from an independent civil action due to the wrongful conduct of the respondent. And your lordships, the threefold test is clearly established in our arguments, and moving on to the next rebuttal, the respondent submit that the petitioner should have claimed the remedy against Mr. Gupta. However, the appellant submit that the respondent intentionally interfered with the marriage in the marital life of the appellant, and the husband did not have such intention earlier, and it is clear from the annexure 1 showing the messages, various messages which state that choose us, leave her, she's not letting you to grow, and etc., which was stated, and she's saying that when you will come back to me, which clearly establishes that she's influencing him to leave the appellant and enter into a relationship with her. So with these rebuttals, I rest my case, your lordship. Much obliged, your lordship.
So, general court, you will not find a respondent giving reply to reply, but exceptional verdict.
Much obliged, my lord. I just want to conclude final lines, my lord. Here, autonomy of spouse is central. Imposing liability on others undermines the principle. Here, harm alone insufficient without duty and legal causation. Here, consortium, it is the spousal right, not enforceable against third parties. Without recognized legal duty, even wrongful conduct isn't actionable in tort. My lord, for the petitioner, remedies exist within matrimonial law. Extending tort to strangers creates unbound liability. My lords, the alleged damages are either too remote, speculative, or unproven, and in the absence of the recognized legal duty, no compensation can be awarded. What cannot be precisely proved cannot be generously compensated. My lord, the petitioner have been failed to establish their claim against the respondent and cause of action. So it is subjected to be dismissed inter alia. Much obliged, my lord.
Thank you, learned counsel.
Much obliged.
We need a place where we can look at clarity.
Present in the 1918 for valedictory for okay half an hour. Okay, and declaring announcing the
you.